So good morning.
Good morning to you.
So totally new looks
Yes, a makeover for COVID.
within a week.
Yeah.
Initially, I thought that it's a familiar face. Then I read Kannan Krishnamurti.
Okay.
So welcome to the platform. Uh, in this platform of Beyond Law CLC, which we all lawyers and other professionals from Chandigarh are hosting large number of seminars. With the flux of time, we have got students and lawyers and other professionals from Pan India. So the last time we met, and after 2 weeks, there's a sea change. People are joining it, and the fact that you and Justice KURIAN Joseph have joined together to help us understand the nitty-gritties of arbitration, mediation, and fine nuances of the online dispute, that would be a fantastic endeavor. Large number of people would be doing. So it's going to be 11 o'clock, and we will request you to come on the board. Before I formally ask you, just though we are Justice Kannan, if you think in which field we should make him say that he's good at it. If you go in the Google, you will find that he's a good author. You get fascinated by that. If you look at mediation, you get more fascinated. Once you find as a judge, it's more fascinating. In the English, we say it is good, better, and best. But while I was going hurriedly through your resume, I found that there's no further word after the best. So how could I sum up that you are a package of all? Like 52 cards and then 2 jokers, 52. 52 cards will also not make. The entire pack of cards is in you. You are the entire, people get fascinated by you. The fact that in the early morning, we are just at the right side, I am just admitting the persons. The factum that your popularity is pan-India, rather to restrict once you are on the online mediation and arbitration. My saying that you have been pan-India popularity would be something bad. In fact, globally you are not. So we have a person on our board who thinks locally and acts globally. Sir, over to you. Thank you.
Thank you so much, because I can't, these words are not sufficient to respond to the overwhelming expressions that you have used. I hope I deserve them at some point of time. Today, I'm associated with a person who's so eminent. I would like to therefore begin with very formal things of anyone can pick up. And I'm sure with Justice KURIAN joining, there'll be profound thoughts as well. I will set my screen on as I'm at all times finding it comfortable to put the screen on for you and run through some slides. As I understand, we are going to be talking today about arbitration and mediation, and how does online process make it better for us, or how can we optimize our use of online process for mediation and arbitration. So I'll just get on the screen right away.
The screen is on.
Yeah,
that's not the issue.
I see that.
So, and Justice Joseph had just pitched in a message that he would join at 11:15.
11:15, fine. So now I thought I will say that priming for online practice. All of us are practitioners. Most of us are in courts. Arbitration is seen as an alternative dispute resolution mode, and mediation just as well. But all of us know that it is through courts that many of the cases get to the arbitral process, and so too mediation. So long as we don't have a standalone legislation for mediation, it is going to be essential that we use court-annexed mediation. And our endeavor today will be to see how we can get past the court process? Or how do we enliven our practice in arbitration and mediation, even if the courts do not refer to us? That is the way we must go for persons to approach court, seek for an arbitrator to be appointed, or having an award, go to court for enforcement. We are again trapped in a system which is already besieged with a whole volume of litigation. So how are we going to do it, even without reference to courts, but actively within the court's purview and within the court's manner of looking at how things go? So how do we prime ourselves? How do we get started to that process is how we are going to be looking at. Some important information for you is some 5.5% of Americans already work from home even before the advent of COVID-19. We are talking about a large population. We are looking somewhere close to about 75 million people already working on online platforms. Suddenly, we seem to have been propped in there. Hitherto, the understanding was persons who are computer savvy, persons who work from home, or persons who can write their codes and then make it happen for people. But the lawyers are joining the bandwagon, the judges are joining the bandwagon soon. And that is the way human evolution has come about. That in all adversities, we can still find some method of making the best out of things. So in these adverse circumstances, when we are able to look at the online process, that is obvious. That is the way human ingenuity will work. And suddenly you find now, from what I see, Vikas said in the morning, from the time we began about 4 weeks back, there has been a makeover for me personally, but I know he has been able to incentivize people to join in webinars, to improve the knowledge, to share information from eminent speakers. I wouldn't really see myself in that galaxy, but I'm sure from how we have been able to get people coming, to get persons like former judges of the Supreme Court, very leading practitioners across India, all of them coming on our platform, is a manner of saying that everyone wants to contribute, everyone wants to join in. Now, therefore, how do we integrate these new practices in the arena of arbitration and mediation, having known how to do it? Just thought some of those issues of what we can do, we must at all times keep in our mind, at the background, that there are some limitations for our practice. Of everything of what is possible in physical presence may not at all times be possible in this video mode. Because we keep saying that it's an important thing that in physical presence we are able to see the persons, we are able to read the people in close proximity. How is his body language? There is a whole lot of psychological study about body language. How does he sit? Does he have twitches on his faces? Does he keep his chest closed? Does he keep his hands drawn? Is he relaxed? Is his shoulder down, or is it all cramped? All these things probably in physical presence you'll be able to notice, and gives you enough understanding as to how you must pose your question, how you must how you should approach issues for him. All that will be absent. And again, it is possible listening in some way. I can catch your attention by my just physical presence, but here you can mute me, you can close me, you can go out, you can walk out of the place. All that I will have no control. So in mediation or arbitration, where you need to have a complete attention drawn to either the arbitrator or the party or one to another, it could be lost. So therefore, we must know that when we are opting for an online process, we are not really thinking of situations that in all kind of conditions we'll be able to develop practice. We just have this in mind. And sharing the warmth presence of parties is such an important thing. When you come, especially in Chandigarh, I've experienced there is a general warmth of the persons, a bright, a cheerful face, or sharing a coffee or tea. All that we can do to ourselves probably is to help ourselves to a coffee or tea in our cup. So therefore, that is a problem. You won't be able to share the warmth of friendship and exchange. So therefore, that is something which you'll have to cope with. There is nothing you can do about it. But then these are the things which may not happen. And therefore, we sense all these things. How are we going to improve the situation is how we'll see. Now, just know some of the skills from the time when it was all started some 4 weeks back to I'm able to see how because begins, how the person gets all the participants involved. So there are concerns at all times expressed when we are talking about arbitration. Sometime back, I passed an order with reference to some volleyball federation. And this was something which was between the parties. In court, every order that is passed is probably put in the website of the court itself, and orders are public. When we are talking about arbitration, orders are not public. It is merely for the benefit of parties. If they had gone to court, the order could become public. But an arbitral award is never a public award unless somebody wants to share it and there is some public element involved there. Otherwise, it can all be kept confidential. Now, can we keep it confidential? The same thing, confidentiality is such an important thing even in mediation. Can we keep all conversations secretive? Can we keep a confidentiality to it? I want you to know that in all this, or what you're going to be seeing, in the Zoom, for instance, there were issues of confidentiality, there were issues of safety which were raised, and it was even stated the government of India was not promoting a Zoom call. Probably they had other options. So it all will even out over a period of time. But as I noticed that even on our screen, you must know that there are quite a few features there. You will find that there is a security icon there. That press that security icon, you will know what is possible for you to do, what is possible for you to ensure that there is no breach of security. For instance, you can close a meeting. You can keep a group of persons and not allow anyone else to come. It is possible. You can mute recording for everyone. It can't be done. You can ensure that it's not done. And it's also stated that the conversations are encrypted and therefore it can't go out only to persons. It's possible for you to make it available, a free access for persons, or you can give, as the system itself generates for you a password, it is possible for persons to come only by using that password. Only those persons can do that. And we can ensure by disabling recording function, it may not be uploaded elsewhere. Therefore, you ask at the time when you are setting up an arbitration or mediation, would you mind having all the things recorded or not? You should be asking. So that is the first thing which you will do. It's recording they are not permitting. Is that fine? Or we are allowing for recording. Is that fine? So arbitral process, probably you don't find too many objections, but in mediation that is surely a thing. Recording of a thing could be a serious problem for parties. May go back to court if the mediation does not end with finality. But arbitral process, it should end normally. An arbitral process, unless you find that the arbitrator has in some way compromised his own impartiality, you will find that any order passed by an arbitrator gets final, subject to whatever variations which are possible in appeal or where there is a scope for setting aside for some other cause. But in mediation, there are so many chances of the parties not finalizing something and going back to court or having other options. Unlike in arbitration, where there will be a finality to an arbitral process. Mediation does not at all times do that. So therefore, keeping it confidential could be very, very vital. And ensure also at the beginning when we are talking about arbitration or mediation, that your internet connectivity is stable. It is possible for another person at the other end, it's not stable. You can help the person with some information. Probably you can say, if you keep the video off probably with low bandwidth, it's possible for you to be heard at least, even if you can't participate in a video conference. So therefore, where audio is fine in a situation where video is not there, even then we are talking about online process, and therefore ensure that there is a sufficient bandwidth for a person and there is no problem with reference to the stability of the transmission. That is also essential for you to do. And then as we find rules of communication, we are used to in the mediation setting of beginning the talk or beginning our conversations by saying, I'll set down certain rules. Here one will speak, the other one will not. We see how frequently it gets breached. You will find if a person talks, the other person will also talk. But in the kind of virtual meetings or what we set up, two persons just can't afford to talk. So therefore, you are there as an arbitrator or a mediator, or you are participating in something. Set something, know for yourself. If there is some issue which you want to make an intervention immediately, raise your hand. So therefore, you have the arbitrator saying that. Or you may probably, if you are a counsel representing a party, you can even ask, because you can't be sitting quiet when somebody is making some argument, somebody is making the presentation, which is completely misleading. Or it is an accepted thing, you don't want a dilation of facts, and therefore you say it can stop. In all situations, if you are a mediator or arbitrator, say how another person can come in. Even if you have set down the rule, you will not intervene. There will be occasions when interventions will still be possible or still be necessary. Or if you are a litigant yourself, or if you are a counsel representing a party, ask the arbitrator or mediator, sir, it's fine that I will not interfere when the other person is talking. But if there is a need for such an intervention, if there is a compulsion for me to go somewhere in between, now how do I do? I'm sure any person, or you may even prime an arbitrator or mediator if he is not able to, or she is not able to suggest. You can say now, do I put my hand up? Will you notice and do something? Or can I put some question there in the chat box, which you'll keep seeing? And in the chat box, I say, now I want to make an intervention. So therefore, this kind of interventions during the talk, during conversations will keep happening. It will just be possible. Therefore, you should remind yourself about that. And more than anything, if you are there participating in the virtual meetings, you need to be really familiar with reasonably all the features which are available there. You'll see where is a mute button. You'll see where is do you want to share the video or not. You'll see who are all the participants who are there. How do you share your screen? You want an annotation, you want to annotate something, you want to keep a blackboard, you want to have something written, all that will be possible. So therefore, for you to understand all the various features of this will become essential and relevant. And just a simple introduction is all that is going to be necessary. It will not require too many difficulties for you. If supposing I say something like, what do I see? How do I need to know? You can put your cursor on each one of these. If I'm putting somewhere on record, disable participant annotation, show names of annotators, hide video portal, each one of them is possible. Therefore, before you get on with a program of mediation or arbitration, ensure that you are familiarized with yourself with reasonably all the tools or what are there. That apart, the more important thing probably when we are looking at the security tools, I just thought I should let this be a little more elaborate for us. For there is no worry right now if it is where the parties are prepared to go and participate in virtual meetings, that these can all be secured. You can give that assurance. Right now, that kind of facility is available. If you have a question in all these important things like Microsoft Teams, or you have Skype or Zoom, in each one of this, there are security features. If you have a doubt, you can communicate to the people. The questions, they answer you in umpteen ways. It's amazing that you raise the question, in next minute there is somebody there And it's just not a machine which is answering. You're able to see that there is an actual person sitting at the other end who is responding to you. He gives his name, or she gives the name and says, now I'm responding to you. How are you doing? How has been your experience? That kind of, if I want to know or to ensure that there is some security concern which the party has, you can actually elicit how it can be set to the maximum and then share it with the party. That is possible. And there is a Zoom room which you will find there in the taskbar. You can make the meeting private or public. In the account setting page, you will find you can disable recording. You can lock a meeting and prevent anyone from joining. These are things which you will probably know, but I thought I should tell you, because in many of situations of virtual meeting, the questions that keep coming to us are, how could it be confidential? Is it not possible for me to record when I'm saying I shall not be recording? Can I not breach it easily? It cannot all be possible. It's possible for you to set everything and ensure that security is kept to the maximum. What would happen if the person, the service provider, breaches security and gives it away somewhere? They'll all be answerable legally, and therefore that ought to keep us reasonably comfortable. For our operations, at least, I don't think we need to worry too much of what we are sharing. I don't believe that there is going to be a very serious breach issue. Of course, there are always the naysayers, and there are persons who don't believe all these things. The same way as Aadhaar, many people don't believe, even still, they think it's not correct. But then we know how important it is, and not every one of the personal information could be breached very easily. That's just for you to know that security tools is not a very, very serious concern. And I've now, for what I started with 4 weeks back, I wouldn't have been as comfortable. Now I've elicited a lot of information to know it can be secure. Our conversations can be secure. It's possible to keep all the settings in such a way that it is not easy to breach for any person. And where does our online process, for stages of arbitration, where online process could be effective? So this is what I thought, because this is experiential. You must believe me that I'm doing this, and therefore if it is possible for me, it's possible for any arbitrator. It is possible for any lawyer to suggest any one of these things. Just last week, for some arbitration which was to take place at Delhi, where I couldn't go to Delhi, then obviously the only thing is this mode, and one of the parties is a government department. So therefore, assure yourself that governments have all internet facilities, all government offices, they are trained well, and therefore you don't have the kind of apprehension or what you may have probably had, and that will there be some person there at the government office who will be able to respond? Will they be able to join? It's not such a worrisome feature any longer, that government offices are well primed for this. And procedural order, normally a person who is participating in arbitrations know that meetings are convened to elicit some factor where an arbitrator has to declare that there are no issues which will disable him from functioning as an arbitrator, as Section 19 would require. He needs to probably assure that he has not associated himself with any party previously. That kind of information that will be there. And again, we set the schedule of dates. In any arbitration, we know that it is important that various stages of the arbitral process, like when should the claim statement be filed, when can the reply statement be filed, when are the issues going to be drawn, when can the discovery and inspection of documents be done, when is the case set for hearing. Now, up to that, at least about 4 or 5 stages, we have a procedural order. We even speak about the fee, or what is the arbitrator's fee. All that which goes into procedural order, or the minutes which are drawn, it can be done purely by virtual meeting. And the next time when you are a lawyer and there is an arbitration, an arbitrator is appointed. Let us talk about a lawyer. Many of you are probably lawyers, and therefore I should say, if you are a lawyer, please make a request to the arbitrators. If he is now setting up a date for a sitting, and on that day it's not possible for you to be available, you are going somewhere, so that date is not convenient. Don't say like that. we can only look at some time and whether a convenient date could be made, and then request the arbitrator, sir, is it possible to set up this first hearing where the party's presence may not be necessary, or where I'm prepared to send all the documents like Vakalatnama and things. And can we have the procedural order drawn on a virtual meeting? It's possible. And the statutory disclosures of arbitrator and fixing, all that can happen. Interim orders, for instance. There are situations where the Arbitration Act itself makes possible arbitration on a fast track mode. But many of us don't use it. It is possible for us to be utilizing those provisions where you're not going to be requiring any oral evidence. If it's all documentary evidence and if you want an interim orders can be pressed through a virtual meeting, and therefore this again an arbitrator himself may suggest, and if he suggests that, don't be averse to that. In fact, I even realized that some of those wet palm situations, or what can happen in court.
So, sorry to interrupt you. Justice KURIAN Joseph has joined the board. I would like to welcome him. The platform is today blessed because in the pack of cards we have 4 Ks, but we have 2 Ks which match to the 2 into 2 compound. Sir, Justice Joseph, welcome to the board. The entire platform is extremely delighted that you have accepted our request to come on the board. Justice KURIAN Joseph was one of the judge who believed in what he preached, he used to practice in his judgments. Inside the court and outside the court, it was always in the court, it was free to hear him. Outside the court, it was also free to hear him. And the fact that he has accepted our invite, the words would fall short for expression of gratitude on behalf of Beyond CLC. Justice Joseph,
Thank
over
you.
to you for a minute. Yes, sir.
My brother Kannan can continue. Yeah, I'm here.
Sir, it's a pleasure, sir, to be associated on a same platform as you are doing. Nothing gives me a greater sense of happiness. And so,
Pleasure and honor is equally mine too, brother Kannan.
it's a humility, sir, at all times. I'll just run through in another 5 minutes, sir, and then it's over.
Yes.
And then you can join at any time, sir.
Fine.
I was only trying to say at what stages of arbitration online process could be effective. And I said interim orders are surely situations where you don't require a person attendance. It's possible for you to be, therefore, requesting the arbitrator if he says that he is setting a date. Sir, can we do it through your virtual meeting mode? So I'm sure many arbitrators will prefer that as well. And if the arbitrator suggests that, don't feel worried about it. Like I was saying, you don't have the sweaty palm situations when you are having a virtual meeting. You are at the reasonably comfortable. You are not overwhelmed by the presence of persons. So therefore, for those persons who feel tongue-tied or something, it's still easy and possible. And scheduling communications with the secretarial staff or arbitrators, it's easy at all times to be calling the secretarial staff of the arbitrator, go through that kind of a thing. You don't need to go present yourself and ask for some time or when we can reschedule, or if there is a problem about the date which is already fixed. Go engage in online communication. Even now, probably in many situations, I see there are emails coming to you. Sometimes the emails are not appropriate. They say other things also. Sir, how are you? The arbitrator's letter to the arbitrator seeking for an adjournment comes with all those niceties as well. Probably you don't say anything like that in court, do you? You don't say in the first paragraph, I hope your lordship is doing well. We don't do that, obviously. So therefore, the same way we must see when we are applying for an adjournment or rescheduling a date or something, you do only appropriately stay confined to what you need to be stating. And it is possible to engage in pure communications like that through online mode to seek for rescheduling of things. And seat of arbitration. And this is something very, not very tricky. But sometime recently, when we had a talk and when Justice A.K. Sikri was there, he was making a reference about the seat of arbitral proceedings. I'm in Chennai. There is a party in Delhi. the arbitration, the order was passed by the High Court of Delhi, appointing a person like me sitting in Chennai as the arbitrator. I've said initially we started the proceeding somewhere in Delhi. Later it was elsewhere. How do you determine the seat of arbitration? Now, where parties are sitting in various other places and then you are connected through a virtual mode, how do we understand the seat of arbitration? We all know if your conditioning is through a civil procedure code, we understand that parties cannot invest any place with jurisdiction which already it does not have. So, for instance, if there is a contract entered into between parties at Chandigarh, the defendant is in Ahmedabad, where you want to file a case, you'd probably go to Ahmedabad, where the cause of action arose, or where he resides, or where the document was made at that time. You won't be able to say in the document that Calcutta will be the court of jurisdiction. It is not possible for you to invest a place of jurisdiction in a place where there is no cause of action, defendant does not arise, or it is or there is any other bar. But it is not like that. There is a singular difference. There is a difference with reference to mediation or arbitration, and the civil suits. And that is brought out through a decision of the Supreme Court, where you have Indus Mobile Distribution versus Datawind Innovations 2017, 7 SEC, page 67. The Supreme Court has explained that it is possible for you to fix any place as the place, a seat of arbitration. Why is it important? Seat of arbitration will still be important for you to determine when you have to prefer an appeal against an order which is passed, when you have to apply to the court for setting aside, when you have to apply to court for execution. All that will have a bearing to where the seat of arbitration is. And that is possible. Therefore, there is a kind of a fluidity which is possible for you to approach and invoke and secure to yourself that benefit. And in arbitration, as well as in mediation, you'll probably, even at the beginning, you'll say for assure, if it is already mentioned there in the document, it's fine, where there is an arbitral process where it could be stated that this is the place of arbitration. But then ensure at the time when you're beginning an online arbitration or mediation, that parties understand what the seat of mediation, because for them, mentally, they'll associate themselves the place where they go to the arbitrator's office. From there, in that place, whichever place it is, if it is in Delhi, you think of Delhi High Court or Delhi Court as a court where you have any challenge coming to an arbitral award. Or if it's a mediation, where if it is not a court annexed, and if you are going to take it as a pre-litigation mediation and then take it like a conciliation award, it can still be only the Delhi court. But where parties are different places, ensure you are talking about what is the seat of arbitration. Evidence of witnesses whose presence could not be obtained on account of age, disability, distance. These three situations are contemplated even in the Civil Procedure Code for appointment of commissioners, where a person can't come to a place on account of old age, or there is a disability, a person can't come, distance. It happened to me some time back where there was a witness in arbitral proceedings, a witness, a party witness, who was in a foreign country, who was apprehensive to come to India because he was apprehending arrest on account of some complaint being filed by one of the parties. So therefore, I said, now if a party can't come and its witness is so important, why will we not go through evidence through internet? Now, there was a resistance. I heard Justice Sikri on the other day when we were saying, even in international arbitration where evidence is given, even now when the Supreme Court has now given some directives, don't take evidence through internet is what they say. So therefore, that is one kind of a caution that you may always have, because physical presence could be very important. But if you can appoint a commissioner for any of those reasons, like age, disability, distance, you'll be able to apply for this also internet. There could be some kind of reluctance by counsel at some point of time where they say, so it happened to me in the arbitral sitting where the witness was there in a foreign country and his evidence was given. He was being very, he was evasive in his replies. He was trying to do all kind of things. At that time, when the lawyer was saying, sir, if only the witness is here, I'll simply break into pieces. So I cautioned kind of quiet for him. Don't worry, you may not be able to break him. It's not necessary that you need to be breaking him. I'm sure you'll be able to get the correct answers in the way you wanted. I'm sure you will get used to it. And I found in the second and third hearing, it was quite a large lot of evidence there, large volume of data was there to be uncovered. So therefore, on the second hearing, I found the lawyer doing better. And at the third meeting, I thought he literally had the witness in his hands. And that was the power that he could bring to his cross-examination. All that is possible. Just the same way as in our talks, in our discussions, we are able to now improve from one stage to another through our online process ever since the COVID the situation has tied us in our own respective houses. We are able to see how we are able to improve, and the same thing will happen. So these are one more slide I'll have, and then close that, will be an online mediation when the stages when it could be effective, because that is what I'm interested. I would like to see, to suggest online process every time it may not work, but convening of parties. I had some discussion with some of you there in Chandigarh when I was in February as to how convening is such an important activity. It's just not the stage when you bring them to court, or court assigns a case to you, you come there, you have a date fixed, you come there, arrive. So who are you? We look at parties, we are trying to introduce ourselves for the first time. But before getting them to your meeting, then you speak to them, familiarize your voice, your presence, your approach, everything. Allay any fears that a person may have about the process of mediation itself. All that kind of familiarizing yourself is such an important thing. And if there is some higher, even in stages where mediation is actually in process, and you find they are not able to take a decision, and somebody says that, sir, I'll have to take a permission from my boss for whether I could accept or not. Or a person says, I don't know, my father must tell whether this would work or not in a matrimonial matter. So there could be other members of a family, other members of the staff team or a company who could be involved. In all such cases, find out whether the communication of what that person could give, is it a private only party to take his opinion, or could his opinion be brought, could his involvement be brought even in the table? It can be decided. Previously, we never thought about it. Now, I would suggest if you have parties coming and one of them is not able to come, you can say that even before, sir, this person is not able to join, but he'll be able to join virtually with us. Is it possible to allow connectivity to these proceedings to that person? Can we make that alone possible, keeping that confidentiality intact? All that can be worked out. Ensure that that person does not have access to other information where he can disseminate whatever is happening and confidentiality is lost, because that's a very important thing. How do we ensure confidentiality when any such suggestion is brought, where somebody else from outside is sought to be brought in? You say, how will the confidentiality be addressed? So have that, keep that topmost in your mind. And then finalizing the draft of settlement. Many times it happens, we finally go through everything. We are not able to complete the things, the process. And then say, now we keep the draft. And then you say, now I'll please send the draft to me by email, and share with email. Then go on a virtual mode of meeting with the other side. Fine-tune the terms of the document to ensure that it's possible to do or not. These are some of the thoughts where I thought I should let you know and share with you, because these are things which I have been doing now recently. Convening parties, I almost make it as a necessary tool. The virtual meeting is a thing which I always go through. Whenever I'm saying I don't say that with any ego there. I'm only trying to share my experience. So what I find is comfortable, I'm sure there is another person who will be comfortable. So whatever will be the areas of concern, I'm sure we have the most eminent judge as a participant here. We are privileged to have him. Sir, it will be my privilege to hand the situation, the floor to you to take over, sir.
Thank you, sir. Thank you, Justice Kannan. And before Justice KURIAN Joseph takes over, I'm just reminded that let's assume we are gone to witness a match. We have to just decide as to whether it's a treat to watch Virat Kohli or it's a treat to watch Rohit Sharma. So it's a treat for us. hearing and watching both of you. So thank you, sir. Over to you.
Yeah, a very good morning to all of you. And in particular, I can see my esteemed and beloved brother Kannan. And I can see a Mahaguru sitting here, Professor Balram Gupta. I say a Bhishmacharya of in this field. And so many, of course, I can see. I had very close association when Professor Gupta was the director of National Judicial Academy. And his beloved brother was the Chief Justice of Kerala, with whom we have worked. I can see Varuna, so many people, so many familiar faces here. Yeah. A very warm good morning to all of you, and God bless you. It's a wonderful occasion for me to see you, your wonderful faces, and happy to note that all of you are staying safe and blessed and healthy. That's fine. We had a wonderful introduction from Justice Kannan on the aspects, particularly the procedural aspects of the new terminology that's coming in, ODR, Online Dispute Resolution. See what all things are possible online has been very beautifully explained. Though I came a little late, I've been briefed by one of the viewers here. My apologies for being slightly late. I had committed for 11:30. I had some other assignment as well. Yeah, but all those procedural aspects have been very beautifully covered. So I would like to only deal with the mediation getting mixed with the arbitration. So let me ask you, what is this arbitration? Arbitration, as all of you know, is an alternate mode of resolution of our disputes. So why do we adopt an arbitration? We just want to avoid the normal route of a civil court, go for a trial, then the first appeal, then the second appeal, then you go to the Supreme Court maybe for an SLP. Well, we thought of avoiding that and go to another mode of dispute resolution, that is arbitration, where there is a bit of arbitrariness on the part of arbitral tribunal to see the overall justice in a given matter, not bound by the technicalities and all the procedural rigors of CPC, etc. And then it's a time-bound process. And what happens now? I recently had checked up with many of the tribunals, since I've been in arbitration and mediation for the last more than a year now, ever since my retirement in November 18. Arbitration, mediation, ARB mediation. Well, I could understand that almost 90% of the arbitral awards are either pending in 34 or the next stage in appeal. So the parties have been informing us that sir, there is no point in getting an award now, because all the central sector particularly, they routinely go and challenge it. Whether the challenge should have been admitted or not, it's a different issue. But the way the lawyers persuade the judges know that there is something to be looked into. And generally, judges are inclined to admit a matter in case there is something to be looked into. Well, judges like Justice Nariman, who was sitting with me for quite long in the Supreme Court, they used to tell us, as far as arbitral awards, if the challenge comes to the court, the approach should be the other way. It's not something to be looked into, something grave to be corrected. That should be the approach. And I absolutely agree with him. In all other matters, my approach has been whether there is 1% of justice to be seen, then I used to issue notice. Whereas as far as a challenge on arbitral awards are coming, challenged before the court, the approach to the court should ideally be, if there is a grave error to be corrected, either legally or factually. If not, all other things simply to be ignored because it's the party autonomy. They have gone agreed on a forum, and then there's an award finally. Just not interfere. Let's leave the matter at that. Well, I'm asking a question to all the people concerned in this field. The moment we have chosen an alternate mode, we had a high dream for a finality and in a time-bound manner. And if the awards are being challenged on various aspects and the challenges are being entertained in the High Court for 10 years, then in the Supreme Court, there's no point in going to that. So it was in that scenario, I just wanted to speak to you on a method of the mediation mixing up with the arbitration as well. I can share my experiences first. In one of the earliest of the arbitral tribunals where I was the sole arbitrator, and almost 90% of you know me, I am a passionate mediator, as my brother KANNAN is. He is more passionate than me and more experienced than me, and he has more expertise also. I have my expertise of which I have developed, but he has a lot of expertise. Anyway, I found, in a matter, in the very first sitting, I found this a simple matter, where the parties could sort it out. There is no need for a prolonged trial in arbitration. So I just convinced them. See, what are you fighting about? See, this is all your dispute. So the lawyer said, sir, we have to get instruction. I said, there's no problem. And, pardon me, my dear lawyers, lawyer friends, all of you are my great friends. The problem, what I see in North is, there's a fees per sitting. Well, in my part of the, where I come from, Kerala, I never had a fee per day. I always fixed a fee for a case. How many times it appeared in court doesn't matter, but it was comprehensive for a case, for handling a case till it is over. So in arbitration matters, my request to the esteemed lawyer friends is, just fix a fee for the arbitration till it is terminated. Never fix it for per day. Only if it comes per day, this issue comes. So I knew the immediate response of the lawyers is to get instruction was only because, it was going to have a real impact on their fee. So my sixth sense told me, let's issue an order for the parties to appear. To much of the dislike of my lawyer friends in that arbitration proceedings, I issued an order asking the parties to appear the next time. When the parties appeared, in the presence of the lawyers also, I asked whether you would like to have a mediation. Because I give a brief as to what the dispute is. It's narrowed down to a very, very small thing. It's a money dispute. When the parties said, yes, we'll always welcome that. I could see the faces going little green on the face of the lawyers, but I convinced the lawyers, and I told the parties, whether they come for 5 sittings or 10 sittings, you have to pay the fees of the lawyers. So they were happy. Then I asked the parties to have an exclusive presence with me. I asked. They told me, sir, we have no problem with mediation provided you are the mediator. There was a problem with me. I told them, in case the mediation fails, I will not be in a position to continue with this arbitration because the rule of confidentiality will not be there. It might affect the arbitration proceedings when I continue and pass an award on merits. They said it will not happen. Since you are there, you can be the mediator. And we'll agree 100% and we'll tell you, and we give you the confidence that there will not be any problem. So on that, I just drew up another proceedings and sat there itself as a mediator. And in an hour or so, we had an entire matter settled then. Well, the institution did not pay me the fee because I settled it in the second sitting. I never knew that it has an impact on the arbitrators' fee as well. But it doesn't matter. I was so happy that the parties were happy. That is more important than my fee. That was my realization. Well, the parties were happy. The lawyers are happy since I told the parties that, you have to pay the lawyers their fee. That was my first experience. Second experience in an arbitration. that, after a few sittings, I told them, see, look, this is your problem. Do you really want the tribunal to pass an award? Or do you want your relationships to be maintained? Because you have in any case, you have to continue the relationship. Why do you want to spoil the relationship on getting an award on merits? Instead of one party being happy and the other party have a gut feeling that have a feeling that I have lost, etc., and continuing the fight in another forum. And whether the High Court entertains or not, or District Court entertains or not, still you are feeling that the other party has not been fair to me. I lost it some events. So they were happy. That's what they were. So I told them, do one thing. Let's refer this matter for a mediation. They also it was a 3-member tribunal. So my brothers told me, sir, we cannot mediate here in a 3-member tribunal. So I said, so do one thing, let's refer it to mediator, trained mediator. And one of the mediators sitting, listening, one of the participants in this program, that is, I had no problem disclosing the Varuna Bandari. So it was referred to Varuna Bandari keeping the arbitration proceedings pending. It was referred to there. And she had an excellent procedure, excellent conduct of the mediation, 3-4 sessions, I believe. And the major chunk of the dispute has been settled. Finally, it had to come back because there are certain legal issues to be resolved. So on facts, the parties could agree. And, we were so happy that, the mediator could take it forward and narrow down the disputes on the factual aspects. Then the matter was sent back to us for the legal aspects to be, because that could be settled only in a proper award by the tribunal. So that was an efficacious mode of doing it. That was my second experience. Third experience was, the matter was, the evidence was over, and it was also a 3-member tribunal. Evidence was over, and the arguments are also over. In the process of argument, I convinced my brothers sitting with me, and also the lawyers also know, after all, see, you still have something to take forward, because you don't want to spoil your relationship, because there is a party, I can disclose the name now because the matter is over now. It was RVNL, Rail Vikas Nigal Limited, and NCC. And in that matter, the parties said they will get instruction, because it was the work was continuing also. It was a dispute while the work was in progress. It was a partial dispute in a way, yes. And mind you, after all the evidence is over, after the arguments are also almost over, the tribunal gave a note that apprised them that it is in your interest that don't spoil the relationship, take the matter, continue the relationship, be good good parties, and try to sort out between us. So we give some indications also. And I tell you, both parties sat together, and all the issues which we had framed were sorted out between the parties. 2 issues were rejected, and on the rest, the RVNL agreed for a fair amount, and the party was happy because they are getting the amount. A bird in hand is worth 10 in the bush. They did not get an award for a fabulous amount they claimed, but they got a reasonable award, and the parties were happy, and particularly the claimant was happy because they're getting something in hand now. See, I was wondering, had it not been settled at that time, what would have been their fate now with all this pandemic, etc., continuing, etc., etc., etc. They got the money, they were very happy. That's my second experience. Third experience, that was a case where I'm a sole arbitrator. When again the matter was continuing, in progress. I asked the lawyers, why don't you think of... So a suggestion came from one of the parties through their lawyer. Sir, after all, this is a monetary dispute. Why don't you ask us to go for a mediated settlement? I said, wonderful. Why don't you ask us to sit together and sort it out? Not a settlement. Why don't you ask us to sit together and sort it out? I said, I'm perfectly happy. To me, if the parties can settle a matter, there's nothing like that to me. In my mind, I'm so perfectly happy that the parties reach a settlement. So I drew up a proceeding, asking the parties sit together and sort out the issues. They had a couple of sittings, and they could not iron out some of the. There was still something to be sorted out. They came back to me. They said again. They asked me that, sir, you yourself be the mediator in this matter also, and try to sort out. And we are in that process also. So that's why I'm not disclosing the names also. So these are the 3-4 experiences where I wanted to share with you. I tell you, my dear litigants and the lawyers also. And let me tell one thing to the lawyers also. See, as far as arbitration is concerned, be it the claimant or the respondent, in case you get the confidence of the parties that here is a lawyer who means business and gets a matter concluded at the earliest point of time and gets a finality instead of dragging us further to court, etc. I tell you, you will be a sought after lawyer for the arbitration proceedings, because they have the clients have a confidence in you. Even the opposite side will look for you next time. That because you have been instrumental for a settlement where the parties have agreed on a win-win situation in an arbitration. Win-win is a phraseology used only in mediation, but in arbitration, if you can have that win-win situation, that both parties have a feeling that we had a fair treatment and both of us have won. Nobody has lost. Both of us have won, and our relationship continues. We become better friends. Not even friends. We have become better friends. That is something which you can attain. So, and the Act. Let me come to the legal regime now. The 1996 Act under Section 30 permits, rather it actually mandates an attempt to be made by the tribunal to see whether a matter can be settled in mediation or amicably between the parties, and at any stage. Need not be at the institutional stage, it can be at any stage. That's why I said I gave you my experiences as experiences which I shared with you at any stage. With the agreement, the only thing is that it should be with the agreement of the parties. So making the parties agree is, of course, my dear lawyer friends, you should be in a position to read the fate of a case. The moment it is the claim statement is filed and the defense is filed, and that is one stage. Second stage, when the evidence is over. Third stage, when the argument progresses. If you are able to read the mind of the tribunal, or if you are able to read the fate of the case the way it is going in, at that stage, you should take the initiative to appraise the parties that it is better that we go for this alternate route rather than suffering an award, rather than getting a fabulous award and getting not executed also. So the strength and weakness, you should be in a position to apprise the respective claimant or the defendant, as the case may be. And given the type of relationship you have among the lawyers, I request my lawyer friends also on both sides, for the claimant and respondent on all sides, try to give a realistic picture of the case to the respective parties. The moment you are able to present a realistic picture to the respective client, they will come around. If they may even go for a second opinion, doesn't matter. They will come around, and the confidence that they have in you, you should utilize it to the better interest of your client and to in the interest of justice. This interest of justice is an expression applicable to you, my dear lawyer friends, also. Not the expression that we judges always use. No, interest of justice. You are also parties to the institution. You're also officers of the court, and you also have a graver duty, according to me, to protect the interest of justice. So I request you to take forward these small thoughts and utilize the best opportunity. Now I would like to stop it here, because I'm sure many of you would like to have a bit more interaction. I told the Vikas that no, I don't believe in preaching more. I believe in interacting with the participants, because the better advantage of webinar is that we'll get an opportunity to have a shared platform for the speaker and the participants. So thank you very much for the response that you have shown, and thank you very much in participating, and my great salute to all the big people participating in this webinar. Thank you. All the best. Yeah, to the moderator, I'm here. My brother Kannan is here, and our teachers are here, and mediators are here. You can ask any question. We'll have an interactive session for some time, to the extent of the time permits.
Sir, there is one point which, towards the end, which you said, I had an occasion to use it somewhere. Therefore, I'll share it again. You're saying whether natural justice or how we are looking at it, it need not necessarily only be for a judge. It should be for a lawyer. In fact, ideally, there ought to be some role reversals. And it's essential that a judge turns up in court well-read, like the lawyer does his case. And times have changed when probably Chagla could write in his Roses in December that he wouldn't require any preparation. You would just arrive in the court so that he doesn't have an opinion already. But now, when you have 100-odd cases on your board, if you simply arrive without any preparation, it would be difficult. Therefore, for a judge to prepare himself and then to prepare herself well and come to the court is, it could be wonderful. For a role reversal, I said, and justice cannot be merely residing in the hearts of a judge. It ought to reside in the heart of a lawyer who promotes his client's cause. He must say what is just in a situation. It could seem like a very tough proposition. A client brings his case to me. Why do I judge his case? Why do I need to say whether he should do it or not? It's fine, but you need to apprise what is just. To even put across to the other side what is appropriate and just. In these online occasions, I think it gives a lot of room for engaging in conversations even with the other side. You're talking about the mediation and arbitration and how we can use the online process effectively. How do we prime ourselves? In my view, among other things, you need a different orientation of what you're not already. If you're not being a judge, if you're still an aspiring judge, let's take it like that. But think in your heart that you are just as well a judge for a cause. And it is essential that you reorient yourself to just causes. That is essential for our hard times. Suddenly we realize, like we have never realized before, how the connection with another, a social connection with another, makes all the difference to us. When we're deprived of something, we know the value of what we are losing. So the social distancing or what we are talking about is probably a time also when it makes you realize how important it is that you have that connection to that person. So this is just a thought. I'm taking the cue from where Justice KURIAN said that, and said justice ought to reside in the hearts of everyone. All of us must approach the situation as though there is a cause.
Anand sir, you would have to bring yourself closer to the mic.
Yeah, I can hear. Yeah.
No, slightly sometimes there's a voice cracking, and that sometimes happens because of the distance of the mic. Kannan sir?
Yeah, social distancing does not apply to the mic. Yeah.
Justice. So meanwhile, I can read the question. Amdanish asks, please enumerate the categories of case wherein the court is duty bound to send the matter for ADR.
Yeah, do you want me to answer? Yeah, this under section 89, under section 89 CPC, you can say if the judge is in a position to form an opinion that this is a case worth trying in one of the 4 modes of alternate dispute resolution, he is also duty bound. But the question is a judge mandated? I am more on the, and my brother Kannan also spoke to, see, it's a process where the initiative should come from the lawyers. It should be mandated, the mandate should come from the lawyers. Section 89 is a judge mandate. It's a duty of the court to apply its mind to the facts of the case and see whether it's a case for arbitration, for mediation, and for mediation, each party should agree. For arbitration, it's an agreement. Then it's a log adalat for what they call is a different mode. And the fourth mode, which we have not tried effectively so far, is conciliation or a judicial settlement, in the sense of a judge-involved conciliation process, which I had done in Supreme Court and the High Courts, both in Kerala High Court and in Himachal also. In Himachal, they just challenged me with a case. That was a case between two parties. All of them have got tired with that case, and all the retired judges also tried in Loga. So I never knew that I had my difficulty with the language of Hindi. So I said, let me give a try. And I called the parties. The bit of Hindi I knew, because in mediation, you need only have the language of the heart, not the other language. So I spoke to the parties, and I tell you, paucity of time, I don't want to elaborate it, I settled it. So it all depends on the mindset of the judge also to apply his mind on the facts of the case and get the confidence of the parties, and then then drive them to one of the modes of area. So it's judge mandated is Section 89.
So Dr. Yash Tiwari poses whether ADR system can become an alternative to court during the COVID time.
It should be. It should be 100%. And see, you are going to face a different situation after this pandemic is over. All the filings, there's a floodgate of litigations coming on because of the normal filing, and also on account of the what you call force majeure situations coming in. Disputes are going to be galore now. So definitely at this time, you don't have to wait till the pandemic is over, but even this time also, in respect of pending matters and in respect of the matters which you are going to file also, please, my dear friends, lawyers, you speak to the other side and see whether this can be settled in mediation or in some mode of between you. You don't require a mediator also. Why don't you lawyers also speak to both sides and iron out the crisis and just arrive at what the problem is, and if in case you need an assistance, always take recourse to an independent mediator, and you can have an award, a conciliation award. In mediation, you have to go back, a settlement has to go back to the court and get an approval by a decree. But if you agree, you can have the mediator assisting you as a conciliator and then passing an award of the conciliation award, which is the force of a decree. There's no problem. So always you must, not that possibility, but you must utilize this time.
Ishan Kapoor, the question boggling in his mind is the major difference between conciliation and mediation.
Yeah, thing is that in mediation, it's all the differences are actually narrowing down now. In mediation, the mediator cannot actually. Mediator has to be totally independent. Number one, he is a facilitator. Number two, he cannot give the options unless the parties agree that you can suggest options also. But is slowly coming down. Whereas in conciliation, the conciliator can persuade the parties for a solution. That is not available in the given situation of mediation now. But for us mediators now, my experience also, I give out the options and I tell them what is the consequence and what is going to be the problem hereafter. So it's in a way narrowing down to the stage of a conciliator as well. A bit of conciliation is always there in an effective and fruitful mediation. The difference is mediation. It is supposed to be bound to be absolutely independent and voluntary and in a facilitator mode. And in mediation, settlement has to go back to the court for the court to pass a decree. Whereas in conciliation, you can pass an award which is the force of a decree.
Siddharth wants to ask a question directly. Siddharth Batra.
Good afternoon, sir. It's been my privilege, in fact, an honor to appear before you a lot of times, and Justice Kannan as well. In fact, sir, you have dealt during your tenure as a judge a lot of land acquisition cases, and you've given a lot of judgments as well. You've dealt with a lot of compensation cases as well. You know, in India, because of the delivery system, the compensation has been delayed sometimes 5 years, 10 years, 15 years, and sometimes 20 years as well. So do you think that arbitration is a viable option, or arbitration should be there in cases of land acquisition for assessment of compensation when you see cases under the National Highways Act which are decided via arbitration? So what do you think that which is the better mode, whether what we are following right now or arbitration can be a substitute as well?
Yeah, Siddharth, as you know, for arbitration, there should be an agreement between the parties. There should be an existing agreement. In case there is an agreement, jump at it at the earliest. Catch at the earliest.
I'm sorry, my question is, sir, whether the government should contemplate coming with arbitration and the Land Acquisition Act, because every now and then there's a hue and cry by the farmers and the landowners that they are not being paid on time.
Yeah, that is not a matter of arbitration. In the sense, you know, the government is not a party in the contract where there is an existing clause for arbitration. That's a case for maybe for log adalat. I would suggest that way.
Right, sir. Thank you.
Siddharth, you can mute yourself. Anurag Jain. Can, at the stage of objections of Section 34, either parties can seek to adduce additional evidence which goes to the root of the matter?
Brother Kannan.
Sir, if you are assuming that has been our mindset at all times, to see arbitration as another forum, another tier from where we bring it to the court again. Arbitration, we must see that to be alternative dispute resolution, where the intervention, judicial interventions by court will be absolutely minimal. Therefore, we will not see Section 34 as an appellate forum where, like in Civil Procedure Code, you provide Order 41 Rule 27 additional documents to be filed, new evidence to be given. It should be completely avoided. I don't think courts will be so easy to accommodate to accept new evidence to be brought there. I will think there's simply no scope. There could be always exceptions. You can bring out the extraordinary situations where some important evidence of what was which could have been good enough to review a case. That could be something arising like that. When you bring it there for a challenge, and then you have something so important, you bring it there as fresh evidence. Otherwise, I would think there is simply no scope.
Yeah, it all depends on how extraordinary the situation would be. As the Chief Justice said, you know, an extraordinary situation may call for an extraordinary remedy. So it all depends on how you are able to impress upon the court how extraordinary the situation would have been. How the cause of justice has suffered. If there is a miscarriage of justice. These two, in case you are able to convince, maybe the court might agree. But as brother said, it will be absolutely slow for the court at that stage to permit you to go for additional evidence. Yes.
So according to you, there is a little window. It depends upon the pervasive skills and actually how does it actually go to the root of the matter.
It depends on the factual situation, whether there is a failure of justice or there is a miscarriage of justice or there is a grave injustice. These three things the court will definitely have in its mind when you ask for additional evidence.
Primarily on the same guidelines of Order 41, Rule 27.
No, more narrower, if I can use the double comparative.
That's fantastic. IP Singh, should there be a provision to fix lump sum fees of the arbitration or upper limit to curtail the same? What is your take on that?
Arbitrator's fee.
Yes, sir.
Yeah, I would always say I am willing to always be guided by the Schedule 4. The lawmakers, why did they give a schedule at all? They gave a schedule for a guidance. So left to me, the arbitrations should be guided by Schedule 4. But only difference, I would say that in Schedule 4 for arbitrators fee for about 20 crores, that upper limit is not to 30 lakhs, but its upper limit is that 19.87 something, plus that limit of 30 lakhs is on the amount beyond 20 crores, not the total fee. That's the only thing I wanted to say. In fact, that's a judgment, I believe, from the Punjab and Haryana High Court in that regard.
Yes, so that was in respect of this, these matters. Parasnath. When there were two sessions by the judges, morning session and the evening session. Then they came out with the schedule. Pavni Gupta asks, any of you can take the question. Please brief the process of arbitration, mediation and conciliation. How do you go about it?
Please.
Process, I don't know. Probably she wants to know what are the subtle differences between all the three.
Yeah, I said it, no. Arbitration requires an agreement. Mediation requires a willingness. Conciliation requires, again, there's an agreement between the parties. In arbitration, there is an award, which can be challenged under section 34 and goes. In mediation, it is a settlement between the parties, which requires the stamp of the court by a decree. And in conciliation, you have a stronger role for the conciliator. You can persuade the parties, whereas in mediation, the mediator may not be in a position to persuade the parties to go for the settlement. In conciliation, that is available, and you can pass an award also, which is the force of a decree in conciliation. That is under the Arbitration Conciliation Act. These major differences. And at any stage of arbitration, you can use this mediation, not conciliation.
So fortuitously on the platform itself, and I knew Varuna Bhandari because her basic roots are from Chandigarh. I thought she would also like to share a word of thought because you shared that she had played an active role in one of the mediation. Varuna, are you there?
Yes, I am there. First and foremost, I'll be very thankful to Vikas ji to have created this forum where we are able to see each other and meet everybody on this platform. Meeting Justice KURIAN Joseph, Justice KANNAN, and Mr. Balram Gupta is a big, like a happiness concern for me. And see, I have been mediating for 12 years, and I got the opportunity to work with Justice KURIAN Joseph on many matters, where he gave me the opportunity to settle the matters between the parties in the court. They were directly referred to me. See, mediation is the way forward. It is a lifestyle change, and it is how you look at your relationships. So mediation basically teaches you to look at a resolution, not confront, not have a yardstick of law or some rules to look at a dispute. So mediation gives a complete lifestyle change to a person, where you start thinking from the perspective of the other person. So when, as a mediator, you are dealing with a problem, so basically you are empowering parties to understand the interests of the other party and take them away from their stand. So when they are in the court, in a court annexed mediation, so they are sticking to a prayer. So the parties go beyond the prayer and look at their interest and understand each other's problem and resolve. And basically, they invest in a relationship more than the prayer where they were looking for a win or a lose situation. So they move from a win and lose to win-win. So I have completely shifted to mediation. Only I think 10% of litigation I am doing, and there's a lot of contribution and the confidence of the judges that they posed in me when I was getting to mediation. And I'm always thankful for that.
Thank you. So just Mr. Hemant Gupta has asked, it is somewhat akin to what it has already been did. Can under section 34 proceedings of additional evidence from criminal proceedings going on between the same parties can be adduced or not? So that issue probably you have already dealt. So, so Justice Kannan can meanwhile answer it. I'm trying to unmute you.
Yeah, I said,
Yeah.
that question we already responded. No, Justice Kannan and me both told that the scope is very narrow.
Varuna, you can mute yourself. Siddharth Mehta, how do we confront the witnesses with documents if arbitration is conducted online? Also, does it not prevent the tribunal from recording the demeanor of the parties?
Yeah,
If I may.
I can watch the demeanor of all the participants here, no? So that is an impression, that the same impression the arbitrator or the arbitral tribunal can gather when the parties grill the witness with the document, etc. I don't find there is any. The only thing is that no, we are not getting accustomed. The moment you are into it, see, look at the situation. Are we ever been able to? I have a son now studying for law after 11 years of his engineering. So he is now attending online classes now. Can we ever think of a situation? I have a grandchild now looking at online classes from his school. Can we ever think of a situation? So these are all extraordinary situations where they are trying to cope with this. So if we are pushed against the wall and we have to take recourse to such remedies, certainly we will. Suppose this pandemic continues, and I pray that it does not. But look at the situation where an arbitrator is not in a position to travel for some other reason. Can we put on hold the whole arbitration? No, we have to take things forward. No. So I'm trying to work out a situation in a 3-member arbitral tribunal. 2 of them are from a particular place. So I'm asking them, you conduct the proceedings there. I'll join you in conference. Why don't we experiment that? So likewise, new experiments are coming in, and we should certainly experiment. There is absolutely no problem in having an evidence process in arbitration. The tribunal can always watch the body language of the witness.
Alok Jain.
Sir, if I may.
Yes, sir. Yes, sir.
Yeah, because there's just one thing which I wanted to add, that the Civil Procedure Code, when it was modified in 1999 and 2002 through Amendment Act, introducing provision for commissions, the objection again was by the bar that such an important thing as watching the demeanor of witness is lost. We have all now known, if there is one state which has used those provisions so effectively, it is Kerala. In almost all places, you have simultaneous proceedings going before commissioners. So it is ideal. Physical presence is fine, but then I have noticed it. I said in my presentation recently about a witness in a foreign country. What do we do? How do we confront documents? It was possible. What the person did was, I asked the person to take it near the camera. I asked the person to hold that document before the camera. The person was peering through his own screen and said, yes, that is my signature. I admit it. What was originally being denied, and when he was confronted with the signature in a particular document, he admitted it. So again, the same counsel who was cross-examining initially saying that it is possible to prepare his witness, later when he said no, and he was also making reference about the demeanor and things, later he was comfortable. So these are surely matters all. We need to note that demeanor witnesses and things are still possible. I said already, there are certain limitations. Body language cannot be effective, whether there is a facial twitch, whether he is uncomfortable, all those things are what are possible through an actual physical meeting may be lost. But less than ideal situation, but not all which can subvert justice. We can still deliver effectively is what our online experience has taught us. And that is what has been my experience myself.
Let me add one more sentence. Let me tell you, this tearing a witness and breaking him into pieces is something to impress upon whom? Let me ask you honestly. That's number one. Number two, does it have a role in arbitral proceedings? You are not actually eliciting something from this in the strict sense when we have conducted a criminal trial. Testing his what they call credibility or trustworthiness. That is not something which you are testing. We want something, it's actually an information gathering rather than testing the worthiness or unworthiness or trustworthiness of the witness in a criminal trial. Whereas in arbitration, that's not our role at all. We don't want to, breaking to pieces or tearing him, impress upon the clients. Now, what we require actually, some sort of information, some facts, and some situations. That's all the scope. And tell me honestly, have you been able to, in your experience as lawyers appearing before the arbitral tribunals, that your gymnastics or your tearing, has it ever been any impact on the arbitral tribunal or in the arbitration proceedings also? 90% is documentary in arbitration proceedings. To me, I tell you, honestly, I tell you, only 10% remains on the evidence. So, and as Brother Kannan said, in international arbitration, they generally go by the documents only. They never permit you for elaborate what they call the quizzing of the witnesses. No, the scope is very, very limited.
Thank you, sir. Alok Jain, where the arbitrator is appointed by one of the parties themselves or the contract says a particular designated person will be the arbitrator. How would online ADI work because the other party cannot confide in the arbitrator?
See, the arbitral tribunal can assume its duty only when both sides agree. No, there is no question of one party nominating an arbitrator. You have to put it the other side whether they agree on this arbitrator, or they need a change of the arbitrator. If it is a sole arbitrator, and if the tribunal, this is the question of the tribunal itself is constituted only when the parties agree. There is no question of one side, the other side. One side, other side, you can still have before, even before an arbitrator is appointed. The moment you get a notice, you can speak to the other side and you can have the matter settled between yourself.
Yes, sir. So the questions are pouring in, but since we keep the schedule at...
Abhiraj, because there is one question from Abhiraj Chub.
Sir, you can take it. Or should I read it?
Yeah, I read it. It says a person born in India.
What time? At what time that question was posted?
At 12/18/24.
No, one Adiraj has also asked at 12:12. Can I read that? Can a court order de novo arbitration proceedings?
No, I already answered. I've also given the two decisions there. Normally it will not do. I've given the decision. When there can be an exceptional situation, that also I've given the decision in the chat box. So I'm sure I've not detained myself there. The exception is KK Jan. There is a decision there. We can see that in the chat box. So one question somebody is asking, an Indian citizen acquires American citizenship, where will the arbitral proceeding be? It doesn't work like that. Arbitration can be only through an arbitral agreement. An agreement must specify where the court will be a matter which will be decided there through what is contained there in the arbitral agreement itself. I already told you again also about arbitral seat of arbitration. It is possible for parties to determine what shall be the seat of arbitration. So therefore, that's how it should go.
The Buneet Chaudhary says, the scope of challenging the award under Section 34, saying that the award is against the public policy, is very vague. What is your take on that?
Yeah, it's all covered by decisions in what is public policy and what is public policy of India. These are the two distinctions drawn up, and then the Contract Act also says what is public policy is also defined. So the scope is very limited. The court will definitely see what is the public policy that you have issue of public policy you have raised in the question, and if it simply touches on the merits, nowhere you can have any access, any scope for a challenge. But if it touches on the roots, as if it goes against the public policy of India, then certainly there is a scope.
So now two issues are boggling in the mind. One is that we are getting bored with the questions. Second is we don't go beyond 12:30. So it's your take. How do you go about it?
Yeah, we should limit it to 12:30 because every good thing should come to an end.
So now it is 12:27. We have asked Justice Kannan many times. I will ask, sir, you have a vast experience as a judge, then a Chief Justice, then as a Supreme Court judge, and now into arbitration, etc. What do you believe that it's all? We always ask everybody who comes to this platform, what is your belief that a lawyer or any professional should do to make a mark within the institution, so that since we are already flooded with all the lawyers or any professional in the field, that how he should create a cut?
One, be honest. Two, have a thorough preparation. Three, know the scope or limit of your merit to the case. Don't think that don't dream out that you can succeed. Always be aware of the limitation. These three things will make you give you a mark, because you will be in a position to concede, to stop. Once you are aware of the limitation or the limit to which you can go, you can get, you will be in a position to stop. Then the court will always have an impression that there is a fair counsel who knows where the limit is, and your honesty and your preparedness.
So second take is that you have worked, you have been a judge in the High Court as well as in the Supreme Court. Every lawyer like us who are practicing the High Court, one question which definitely boggles is that the reflexes required for a High Court in the High Court to put it across at the first instance is slightly, we get a bigger gap to explain the issues, whereas in Supreme Court the reflexes have to be very fast. So what is the mode of opening the statement before in this process?
Yeah, what you do in High Court in 5 minutes, you'll have to do in 1 minute in Supreme Court. That's the whole difference.
It is more akin to what we play in the domestic and then to the international level.
Yeah. Practically, there is no difference at all. It all, your art of advocacy and your craft with which you are able to present your matter. Be it in Supreme Court, be it in the High Court, makes no difference according to me. It all depends on how crafted you are in presentation.
And what role do you believe that drafting as such plays a pivotal role? Because large number of judges read it at home because they frame a particular mindset. So you believe that drafting would play a pivotal role to help you to do that?
Yes, 100%. Because if you're able to present a summary of your dispute in as less as possible words, as few words as possible, then definitely it will have a great impression on you. Even if you miss the point, also the judge will find. In my experience as a judge, I had several occasions I had told lawyers, this point you have missed, and this is the point on which I'm issuing notice, and at the final hearing stage, you must develop on this point. This was possible only because you are able to present a brief of your case as brief as possible.
That gesture of yours actually shows the difference between an ordinary and extraordinary judge. That shows that you were always why you were considered as an extraordinary judge who could deliver beyond that. So, since we have taken the take, we will ask Justice Kannan, who is in totally new looks today, what is his take that how the lawyer should make a mark? His new thoughts after the ODR issues.
After the ODR, I think to get reasonably familiar with the technology, you can't any longer say that it's not for me. It's for me at my age, at 65 years. And why will it not be for a young person? So therefore, embrace technology with enormous passion. And it should be not distracting you, because it distracts you a little too much if you only want to see yourself, how you're looking good, what you're doing in Facebook. There is so much of information which is available there. Your ability to choose what really gets channelized to your box is what is important. So therefore, what is my take? My take is use technology effectively. There is so much to learn. You don't need to go to Harvard or Stanford You just can be here, get connected to so many important programs. I saw among things, what is it that I would suggest for somebody who wants to take on mediation or arbitration? There are so many online courses which Harvard is conducting. Not very expensive. They are good. So therefore, and everything of what you read or do, try to put it in practice at the earliest. That is the way you can remember those things and to satisfy for yourself whether it works for you or it is not good enough. So therefore, putting them to practice immediately or what you assimilate or what you have heard today is what you should be trying to put in practice tomorrow in the next immediate contact that you have with a client or with a case. So therefore, that is the way to succeed.
So, taking from what Justice Kannan said, I am reminded what is written oft on the online when we read about you, Justice KURIAN Joseph, that they say he's one of the few judges who says he practices what he preaches. Same is with Justice Kannan. We had taken him on board when the lockdown started. He said that I would like to learn it. The way he has developed himself is a lesson to be learned for all lawyers, young lawyers, students, etc. Justice Kannan, we all take you as a role model for all these aspects that how one has to learn. The fascinating fact was that at the same time when Justice KURIAN Joseph was taking the questions, you were also posting the answers at the same time. It shows the volume of knowledge which you have, the speed at which you can type. We all have to learn from them. So it's 12:30 and we are all sorry to the persons to whom the answers, their questions could not be taken. I will ask Devika Raj to propose a vote of thanks. And I'm also sorry that I could not take Mr. Balram Gupta, who is guru not to everyone out in Punjab, Haryana, and being in Judicial Academy, the National Academy. He's a wonderful person. But since we are running short of time, I asked Devika, and then 1 minute talk thereafter I will ask Mr. Balram Gupta just to wrap up in his own style. Devika, vote of thanks from your side.
Thank you, Vikas sir, for giving me an opportunity to thank the doyens of the legal justice system. Being a fresher, it is an honor for me to propose a vote of thanks on behalf of Beyond Law. Kannan sir has broken the chambers of the preconceived notions of generation gap, embracing the change and telling us the nuances of online dispute resolution. It has been immense. We have a lot to learn from him. And KURIAN Joseph sir, I have an anecdote to share with you. When you came as the Honorable Chief Justice of the Himachal High Court, you initiated colloquiums in Shimla. And I used to study in a boarding school called Auckland House School. And to be very honest, when first I happened to attend the first colloquium of yours by chance. So we were in a boarding school and were not afforded chance of going out to Auckland. So my friend said, I've proposed your name to go for a colloquium and we are going together. And I said, I'm not interested. Sundays are very sacred to me. I'm not going outside wearing the school uniform and representing the school or whatever. So she said, no, we must. It's a very nice opportunity. So on a Sunday when it was in Hotel People House, if I remember correctly, and the topic was harmonizing rights and duties. So that is where I heard you for the first time, and you've been an inspiration for me ever since.
Thank you, Devia. Thank you.
And sir, I learned 2 lessons that day from you. One was that rights and duties are the 2 sides of the same coin. And second, you said that principles make a man, and you should never let go of your principles. They should never be compromised. So, sir, I'm thankful to you, and Justice Kannan, thank you so much. And in reality, I would be actually extending my gratitude to you if in my lifetime I'm able to inspire someone as you did to me or many others that we don't know. That will be a true tribute to you, sir. Thank you so much. And Kannan, sir, thank you so much.
We'd like to hear Professor Balram Gupta for a short word. Yeah.
Whom? So whom?
Professor Balram Gupta.
Professor Balram Gupta. Unmute.
It's called the benedictory remarks.
And
Yes, sir.
I just want to share my experience. When I was at the Judicial Academy, both Justice KURIAN and Justice KANNAN used to regularly come to us in our various programs and contribute hugely and richly as such. But I found it difficult that those particular days who had retired, and we keenly wanted to have them in a program, it was difficult to really engage them in our different programs because they had such heavy list of arbitration matters. This even now continues by experience attending the Judicial Academy. And that's my regret that the best of minds whom we want in the Judicial Academy are not being attracted as such. We need to look into this particular aspect. Thank you so much, Justice KURIAN and Justice KANNAN.
Thank you, Dr. Balram Gupta. He has always been a role model for all of us. While he was teaching in the law department, when he was in the donning the robes as a lawyer, and thereafter in the Judicial Academy. So thank you everyone. For the participants, we have in the evening session at 6 o'clock by two eminent persons, Mr. Rakesh Gupta and T.N. Singla. They will each give a session on income tax and tax planning. Those who want to join the session, that will be at 6 o'clock in the evening. You can watch our forthcoming sessions, like us on the Facebook page and the Instagram, or join our WhatsApp group for the latest update. Thank you everyone. Justice KURIAN Joseph and Justice KANNAN. It was a treat. It is a rare occasion then when the lawyers get the opportunity to ask questions to the judge. And it's a more better occasion to learn from them, which ordinarily it boggles in the mind that how I could ask the judge what will be his expression on that process of thought. Thank you everyone. Thank you. John.
God bless you. God bless you. Jai Hind.
Thank you, sir.
And then only മൂന്ന് കാര്യം ഞാൻ പറഞ്ഞു. ഒന്ന്, be honest.